Hello and welcome to StudyIQ. In the previous two lectures, we have seen what is a patent, what is the Indian patent law, and we have also seen the Doha Development Agenda. This session is a continuation to the previous two lectures. In this lecture, we will see what is compulsory licensing. Compulsory licensing. Before we move on to the topic, let us quickly recap what we have learned in the previous two lectures. We have seen what is a patent. We have seen that patent is given for inventions. And in the Indian patent law, we have seen a very important thing, that was the section 3D of the Indian patent law, which says that enhanced efficiency is a criteria. Enhanced efficiency is the criteria in order to give patent to an already existing drug. So enhanced efficiency. Under enhanced efficiency, we said that the patent office has not given a definition for enhanced efficiency, but in the Novartis case, the Supreme Court said that a therapeutic efficiency is necessary in order to be considered as an enhanced efficiency. So from the Novartis case, enhanced efficiency got a clear-cut definition, and we said that section 3D is very, very important. We have also seen the advantages and the disadvantages of section 3D. Advantages and disadvantages. Under advantages, we said that section 3D of the IPR, intellectual property rights, prevents evergreening. We have also seen what is evergreening. We also discussed how commodities, especially drugs, become affordable by the implementation of section 3D of the Patent Act. We have also said that other countries has followed this model of Indian section 3D of IPR. We have also seen the disadvantages. We discussed about the priority watch list in which India is included by the US. Under the Doha Ministerial Conference, we have seen two important declarations. The first one was known as the Doha Development Agenda, and the second one was related to the TRIPS, Trade Related Intellectual Property Rights. So, under the Doha Development Agenda, we have seen what were the favorable negotiations for the developing countries as well as for the developed countries. And under the favorable negotiations for the developing countries, we have said that a new clause was added to the TRIPS. A new clause was added to TRIPS, and the clause was known as TRIPS versus public health. So in this lecture, we are going to see what is the new clause. So our discussion will be on this new clause, or otherwise known as compulsory license. So let us see what is compulsory licensing. These topics are very important current affairs, and there are good chances that these questions can be asked in any competitive exam. And for those who have missed the previous two videos, I would request you to go back and watch those two videos for a clear understanding of this lecture. Now let us see what is compulsory licensing. Compulsory licensing. As we have said, one of the important outcomes of the Doha Development Agenda was that a new clause was added to the TRIPS. Existing TRIPS, a new clause was added. A new clause was added in TRIPS, Trade Related Intellectual Property Rights. And this new clause was known as TRIPS versus public health. You should remember this point. TRIPS versus public health. TRIPS versus public health. And what does this clause mean? The clause means that in case of an emergency, for example an epidemic, a member country can violate TRIPS. So the clause says that in case of an emergency, a member country can violate TRIPS. This means that the government of a particular country can compel a patent holder to give his patent to a third party. So, under this clause, the government can compel the patent holder to give his patent to a third party at a nominal fee that is fixed by the government. At a nominal fee that is fixed by the government. Usually the patent holder will get a fee or a royalty, which will be a lump sum amount. But in case of an emergency, the government can ask the or the government can compel the patent holder to give his patent to a third party that the government asks at a nominal rate which the government fixes. So this was the clause TRIPS versus public health. We said that these clause can be applied only in case of emergencies. So this must be remembered, in case of emergencies. And through this clause, the government ensures that the price of the drugs are affordable for the general public. So in order to make the drugs affordable for the general public, government does this. And this is known as compulsory licensing. But there are certain conditions which a government has to fulfill in order to issue compulsory licensing to a patent holder. So what are the conditions? Let us see. So let us see what are the conditions under which the government can issue a compulsory licensing to a patent holder. What are the conditions? The first condition under the compulsory licensing is that reasonable requirement of the public is not met by the patented invention. That is, reasonable requirement of the general public is not met by the patented invention. So if the government feels that the supply of the patented product is less than what is the demand, and if the product is an essential commodity, the government can issue compulsory licensing and ask the patent holder to give it to the third party at a nominal fee the government fixes. So this will ensure that adequate supply of the patented product is available in the market and it reaches the general public. Otherwise, what will happen is that the prices would be high, or sometimes the supply would be less. So if the supply is less and the demand is more for that particular drug, this will lead to supply demand mismatch and it will not reach the general public. So in order to ensure that adequate supply of this patented product is available in the market, the government can ask the patent holder to give it to a third party, and this is known as compulsory licensing. This is the first condition the government can issue a compulsory licensing. The second condition for issuing a compulsory licensing is that the government should feel that the price is unaffordable by the public. The second condition is price unaffordable. If the government feels that the price of a particular patented product is unaffordable for the general public and it is an essential commodity, the government can issue compulsory licensing, and through the compulsory licensing, the patent holder has to give it to the third party at a nominal fee which the government fixes. So this will make the product or the drug affordable for the general public. So it can be an essential drug. So with this, the government ensures that the prices of the essential drugs are within control and affordable by the general public. So this is the second condition. If the price of the patented product goes unaffordable for the general public, the government can issue a compulsory licensing against the patent holder. The third condition is that if the patent is not working in that particular territory. So third condition is if patent is not working in the particular territory. If patent is not working in the particular territory. So these are the three conditions under which the government can issue a compulsory licensing to the patent holder. The first one being if reasonable requirement of the public is not met by the patented product. The second one, if the prices become unaffordable for the public. And the third one, if patent is not working in that particular territory. If any of these three conditions are met, the government can issue a compulsory licensing to the patent holder. Hope this is clear for you. If we take the history of the compulsory licensing in India, it was only in one case the government or India has issued a compulsory licensing, and that was the Nexavar case. Nexavar is an anti-cancer drug and Bayer was the patent holder. The government has asked Bayer, the patent holder, to transfer it to the third party, that is a Natco Pharma. So here Nexavar was the anti-cancer drug which was a patented product. The patent holder was the Bayer. Bayer was the patent holder, and government has asked the Bayer, the patent holder, to transfer it to Natco Pharma, which is the third party. This became a huge controversy in the intellectual property rights, and this is very, very important. You should remember this next hour case. You should also remember some facts about patents. Let us discuss the important facts. The first important fact regarding the patents is that they are territorial rights. They are territorial rights. It means that if a person having patent in US for a particular product, and if that person wants to use that product in India, he has to apply for a different patent in India. That means patents are territorial rights. The second thing is that in order to acquire a patent, pre-grant opposition is necessary. Pre-grant opposition is necessary. It means that the patent office has to see whether there is any opposition before the patent is granted to that patent holder. So before the patent is granted, the patent office will see whether there is any opposition from the general public. And thirdly, post-grant opposition is also necessary. Post-grant opposition. The patent office will see whether there is an opposition before granting patent. Likewise, after granting the patent also, the patent office will see whether there is any opposition from the general public. The next important thing you must note is that patent is for a certain period. Patent is for a period of 20 years. So, patent is for 20 years. And after 20 years, it becomes off patent. So, let us see what is off patent. Off patent means that after this 20 years or after this protection period of 20 years, the general public can use the patent. That means anybody from the general public can use the technology, use the invention to make that particular product. So, after 20 years, it becomes off patent. The general public can produce this product or the drug. So, example is generic drugs. Generic drugs. A particular drug could be patented and after 20 years it becomes off patent. So what happens? Many pharmaceutical companies will produce the same product. That means the composition of the drug would be same. The drug would be exactly the same but under different names, and we call it as generic drugs. The next important thing here you must note is that the patent holder has to disclose the technical information to the patent office. So disclosure of patent information. Initially, the applicant has to reveal the technical information to the patent office, but later on the patent office will make this information available to the general public also. So, the patent holder has to reveal the information to the general public. So, why this is done? In order to increase the transparency, and the general public will be aware of the product they are using or the drug they are consuming. So they will be aware of what it is, or what is the composition, what is the technicality behind it, or what is the invention. So general public will become more aware of the product, and it increases the transparency also. So these are the important facts related to the patent. So these are important points, and these can be asked in some examinations as objective type questions, or even in descriptive type questions. These questions are expected. This is very, very important. You must have a clear idea about what is patent and what is compulsory licensing, and especially the section 3D of the Indian patent law. So I will sum up by briefly explaining what is section 3D and compulsory licensing. Let us quickly brief. Section 3D of IPR, Intellectual Property Rights, says that enhanced efficiency is compulsory for applying for patent of already existing drug. This was the section 3D inserted by the Indian patent law. And in the landmark judgment, Supreme Court said that enhanced efficiency means therapeutic efficiency. So this has to be remembered. Therapeutic efficiency. The major advantage of inserting the section 3D of the IPR is that it has prevented the evergreening of patents, which was a major problem in developing countries like India. You must also remember that India was the first country to insert a section 3D into the IPR. And we have also seen compulsory licensing. Compulsory licensing is a violation of the TRIPS agreement. Under compulsory licensing, the government of a particular country can ask any patent holder to give his patent to a third party at a nominal rate in case of any emergency, for example, epidemics. So this is all about compulsory licensing. Compulsory licensing and section 3D of the IPR are very important topics for any examination. You should have a clear understanding of both these topics. Next, let us see what is the Information Technology Agreement of the WTO. Information Technology Agreement. Information Agreement of the World Trade Organization. ITA. Information Technology Agreement. The first thing to be noted in the Information Technology Agreement is that it is a plurilateral agreement. So it is a plurilateral agreement. What does a plurilateral agreement mean? Plurilateral agreement means that this agreement is not binding on its members. So it is not compulsory that the members should comply with this agreement. So it is not binding. It is the independent decision of every member country to join this agreement or not. So that is plurilateral agreement. So in case of Information Technology Agreement, it is a plurilateral agreement. It means that the member countries can either join or not join this agreement. So not binding. Plurilateral means not binding on the member countries. So this is a plurilateral agreement. Second thing to be noted in this Information Technology Agreement is that it deals with information technology products, not services. So only IT products are included in this agreement. Second thing is it deals with IT products, not services. It deals with products only, not services. So IT products means hardware. Example, electronic items, mobile phone, LCD, LED, etc. So hardware, example, mobile phone, electronic items, etc. So it deals with only IT products, not services. Services are excluded from this agreement. And what is this agreement? What does the agreement say? So the agreement says that all member countries who become a part of this agreement or all member countries who join the Information Technology Agreement have to reduce their tariff of IT products, that is information technology products, to 0 or nil. So the agreement says that whoever member country joins this Information Technology Agreement, they will have to reduce their tariff on electronic items like that is IT products to 0 or nil. So all member countries who join ITA have to reduce their tariff on IT products to 0 or nil. So this is the agreement. What is the implication of this agreement? If any country signs this agreement, so any country joining this agreement, the market of the country will have more of electronic products at cheaper rate. For example, if India has signed this agreement, Chinese products can reach Indian market at a cheaper price, which will be a competition for the Indian manufacturers. So the implication is that the market will have more of electronic products or information technology products at cheaper rate, which will become a competition for the domestic manufacturers of that particular country. And India is actually against this agreement. Why? Because we have this Make in India initiative, and this agreement is totally against the Make in India initiative. This agreement says that if you sign this agreement, other countries will have access to your market at 0 tariff rate, and this is against the domestic manufacturing policy of India, that is the Make in India initiative. But here you must understand one thing. This Information Technology Agreement was implemented in 2 stages. So this was implemented in 2 stages. And this Information Technology Agreement was not there when WTO was established in 1995. This agreement came into force in the year 1996 at the first ministerial conference, which was held in Singapore. So Information Technology Agreement was introduced in 1996 at the first ministerial conference, which was held in Singapore. And another thing, as we said, this was implemented in 2 stages. In the first stage, in the first stage, which was in 1996, India, without knowing its implications, became a member of the Information Technology Agreement. So, in the first stage, India became a member of Information Technology Agreement, ITA. And this badly affected our manufacturing sector. Around 200 items were included in the first stage. So, around 200 items were included in the first stage. And what happened was like these 200 items, that is these 200 electronic items or information technology products reached Indian market without any tariff. So, Indian market had to absorb this 200 plus electronic items or IT products without any tariff. And as India had signed the Information Technology Agreement, India could not do anything to stop the import of this electronic items into the Indian market. So, India could not use any safeguard mechanism in order to prevent the import of this IT products into Indian market. Again, the second stage of negotiations took place after so many years. The second stage, and in the second stage, the government of India did not sign the Information Technology Act. So, we are not a part of the Information Technology Act right now in the second stage. This was to protect the domestic manufacturing, and India had already announced its domestic production policy of Make in India. So, in order to promote the domestic production and promote the Make in India policy of the government, India did not sign the second stage of the Information Technology Agreement. You must understand what is Information Technology Act and what are the implications of the Information Technology Act.